What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today's video comes to us out of Utah County, Utah, and was originally shared by the YouTube user Divino. It depicts a young man, I assume Divino, being stopped at a park in Utah County by a Utah County Sheriff's deputy named C. King. Now, I've only made slight edits to the video to edit out some language, but you should head over to Divino's channel and give him credit for sharing this encounter. Let's watch some of the video and then we'll come back and talk about the law.
What?
Roll the window down a little bit so we can talk to you.
You're talking to me just fine.
I can barely hear you.
That's a personal issue, I guess.
Okay, do you have your driver's license?
I do.
Can you hand it to me?
No. What crime have I committed?
Well, you're being non-compliant right now.
Yeah, because I haven't committed a crime.
I'm just here to talk to you.
Okay, so let's talk.
So
I'm gonna film you. I'm gonna film you for my safety. Huh?
I'm asking you to ID yourself.
Okay, so the deputy immediately starts barking orders to get Divino to roll down his window and engage in what would have to be, ironically, a consensual conversation. Now, I hope for the sake of the people close to Deputy King that he doesn't seek consent in the same way in his personal life as he does when he's wearing the uniform, because you don't demand consent. That's not actually how that works, but I digress. Divino smartly asks what crime he's suspected of committing, and the deputy says the quiet part out loud, well, you're being non-compliant right now, which of course is not a crime, but it is a crime according to the police. As you can see, Deputy King here is attempting to sort of take advantage of young Divino's perceived inexperience and cudgel him into giving up his identification.
You're sitting behind the wheel of a vehicle.
That's
You're in control of a motor vehicle.
That's off.
So I'm asking for your driver's license.
And I haven't committed a crime, so I'm declining that.
All right, go ahead and make it harder on yourself.
Okay. Like, I haven't even done shit. They just barely got up here.
He tries to stretch the law into some obligation Divino might have simply because he's in a vehicle. And Divino wisely points out that the vehicle was turned off and he's sitting in it while it's parked. So the deputy, realizing he's being outsmarted by a kid, goes on to the only tool he has, because in all of the holsters on the bat belt there, none of them house an abundance of people skills. So all that's left is intimidation. So go ahead and make it harder on yourself is the only thing he can come up with. Basically, that's the same as, here's the deal, or we can do this the easy way or the hard way, or any other silly phrase that the police like to use as bully tactics when they don't get immediate compliance from people. But let's continue.
And what's the issue, man? Why are you being so uncompliant?
Because I never had a good experience with cops. I've always been like racially profiled or some type of, like right now, first thing that whatever dip said, his eyes are glossy. I haven't smoked in God knows how long, because I'm trying to get a job right now. Like, I'm literally staying sober so that I can have a better chance of getting a job.
Okay, so roll down the window and
homie just comes up and says, oh, he's smoking weed. Like, yeah, go yourself. Nah.
So here you notice that Divino mentions that one of the other officers have already made an accusation that he's smoking weed. And he takes exception to that immediately because he knows, well, he hasn't done that. It's a perfect example of police officers knowing exactly what the cheat code is to sort of get into a vehicle and search it. So they say it, whether it's true or not, just to lay the foundation for what they intend to bring forth.
I haven't even done.
Someone talk to me.
I'm talking to you right now.
Okay.
Okay.
So roll down the window, talk to me. We can have a real conversation.
We're having one right now, aren't we?
No, not really.
Okay, well,
Trying to dock through a window, a closed door and a tinted out window.
it's pretty open. We can hear each other, so that's all that really matters. You can see my hand. I ain't doing nothing. I haven't committed a crime. Y'all haven't like, I don't know. I don't know why 3 of y'all pulled up on me when I haven't done anything. I'm really like, I was about to get out of my car and just go on a little hike. Because I'm like, clearing my mind. I literally have my book right there too. I was going to read my book while hammocking and shit.
Okay. You can still go on a hike. Go read your book.
So what do you guys want?
We just patrol the canyon areas and we stop out and talk to people.
Alright. Well, we're talking.
So, that's all.
Alright. I'm not like...
But you're acting so completely opposite of what the average normal person we deal with. it raises suspicion.
I ain't the average person.
So, you got a criminal history?
No, I do not.
Because you're acting like it.
Well, I don't.
And there it is. You're not acting like a normal person. You're acting like someone who has a criminal history. This gets on my nerves so bad. Let me let you guys in on a little secret, and you can look this up in the rules of evidence if you don't believe me. But you know what is almost never relevant to the facts of a case and almost never comes into the guilt phase of a criminal prosecution? A person's criminal history. Now that might surprise you, but why do you think that is? There is an evidentiary rule referred to as character or propensity evidence. The rule basically says that evidence of a person's prior character trait or prior conduct is not admissible to prove that the person acted in conformity with that character trait or conduct in a particular case. There are very limited exceptions to this, and it's not really necessary to go into all of them. I'm not trying to get into the weeds. I'm just saying that it's not even admissible in a court of law in most cases what a person did in their past. So it shouldn't matter to cops on the street for the most part. The reason that we do that is because we want the trier of fact, the judge or the jury, not to hear evidence of your past wrongdoings nor your good deeds. That's called improper bolstering, by the way, in the guilt phase of a case, because we don't want juries and judges to decide that you're a bad or good person and then make their decision about the facts of a case or the evidence in a case based on what they think about you as a person. So we don't allow stuff like that into the evidence of a case by general rule. Now again, there are exceptions, but that's not the point. We want the trier of fact to base their rulings to the extent possible on the evidence of the case at hand. There are really only 3 places in the criminal justice system where your past matters. 2 of them are complete BS and should not be allowed to happen, but they do, and then 1 of them is fair. The first place that your past matters is before you ever get to the criminal justice system officially, and it's in dealing with the police, like here, because they decide whether you're a good or a bad person, and that helps them decide how to deal with you. That's complete BS. That's why it shouldn't matter what his criminal history is when you're dealing with him, unless there's some evidence that he's been violent to police officers before or whatever. But for the most part, that really shouldn't matter when you're on an encounter with somebody. I guess it should matter whether you have a warrant or whether there's some outstanding charge against you that might force you into a desperate situation. But as far as your criminal history is concerned, especially where there's no way for the officer to know that unless you tell him, it really shouldn't be something that's used to accuse you of being a bad person like was insinuated in the case here. The second place that it seems to rear its ugly head, and it really shouldn't matter at all, is when the prosecutor is making an argument for a high bond or making an initial offer on your criminal prosecution. And that's BS too, and here's why. If a prosecutor can focus on you, the person, and your bad history, it will encourage him not to pay close attention to the actual facts and evidence in the case. That's why a lot of times cases get dismissed in later stages, even after the probable cause phases, because prosecutors almost everywhere make a decision to push a case forward based on their subjective feelings about the accused instead of the facts and the evidence in a case. That's also BS, and it shouldn't happen. Every single time that I got a case that I was supposed to prosecute, I looked at the actual facts of the case. It didn't matter to me what the person had done in their past. I wanted to know what were the facts leading up to this, because in my opinion, that's all that should matter. That's all that should matter. You should make a decision based on how the evidence was gathered in a case, whether or not the Constitution was followed, before you look at anything to do with the defendant or the accused's history. Because what really matters is whether or not a crime was committed, and then whether or not the evidence was obtained legally and within the constitutional limits, before you ever consider whether somebody has a bad criminal history. But again, I don't do the job anymore, and that's part of it. And then the third area where it might be legitimate is in sentencing. After a person has been lawfully convicted in a court of law, in that case, I do think it's appropriate to look at a person's criminal history, both good and bad, because you want to know who the person is that you're getting ready to sentence as a judge. So if you have no criminal history, you might get a mitigated sentence. And if you had an extensive criminal history, you might get an aggravated sentence. But that's based on your criminal history, and that's after you've been afforded due process and convicted lawfully in a court of law. And that's the only time it should matter. I'm going to get off my soapbox now, and we'll finish the video.
Okay, so if you're not doing anything wrong, you don't have anything to fear, then why are you acting so non-compliant?
Because I don't f with 12.
Because what?
I don't like police. For reasons like this, you feel?
Is your name Patricio?
It is. Patricio, yeah.
Patricio?
Yeah.
Okay.
Yeah.
All right. Well, how old are you, Patricio?
I don't gotta answer questions.
You in like your 20s?
I'm getting there.
Huh?
Getting there.
Getting there?
Yeah.
You 18?
Y'all got my name, right? You can search it up. I'm sure of it. Got my plates, like...
Huh?
You got my plates.
Yeah.
You got my name. I'm sure you could search it up in your guys' system.
Not really, because the reception up here is horrible.
Well... Yeah, that's true, huh?
Yeah.
Yeah.
All right. Have fun, dude.
All right, you guys have a good one.
So you heard there at the end the ultimate jab. They had to get the last word, and the deputy says, well, we'll just sit on the car and watch him as he's leaving. So it won't be long if Davino regularly visits this area that he's going to get stopped and have a canine run around his car so that they can be satisfied that he doesn't have dope within the boundaries of the set they claim. Now that all that's out of the way, what does the law actually say about this type stuff? You remember our last video was a deep dive on Pennsylvania versus Mims. You remember that the holding in Mims was pretty broad, and it's been systematically abused by law enforcement officers ever since it was decided in 1977. But one part of Mims that was in a footnote was the majority's retort to the insinuation that this is going to be carte blanche. And they said in the footnote in Mims, look, we do not hold today that any officer who has an occasion to speak with someone in an automobile can just order that person out of the automobile. It's only after a lawful traffic stop that Mims applies. And so what do you have here? You have a person parked in a motor vehicle not pursuant to a lawful traffic stop. So the question then becomes, in Utah, as Deputy King suggested, can an officer demand that a person identify themselves simply because they're in control of a motor vehicle? Or was Deputy King just trying to bully young Davino into believing he had a legal duty to identify himself? Let's look at Utah Code for Motor Vehicles 533217, license to be carried when driving a motor vehicle. That's right, driving a motor vehicle. The licensee shall have his license certificate in his immediate possession at all times when driving a motor vehicle. A licensee shall display his license certificate upon demand of a justice of the peace, a peace officer, a field deputy, or inspector of the division. But again, this subsection is under the title when driving a motor vehicle, so it only applies to driving. A person who violates subsection A1 or AB is guilty of an infraction. That's important. Well, he wasn't driving, so that statute doesn't seem to apply here. Well, what about demanding ID otherwise in the state of Utah? Let's look at the next code. Utah is a state where the legislature has passed a law compelling identification for certain interactions with police outside a traffic stop, so let's take a look at that law. Utah Code 77715 states that a peace officer may stop any individual in a public place when the officer has a reasonable suspicion to believe that the individual has committed or is in the act of committing or is attempting to commit a public offense and may demand the individual's name, address, date of birth, and explanation of the individual's actions. Now, of course, the explanation would be self-incriminatory, so we don't have to worry about that. But again, the officer can demand name, date of birth, and address from a person when they have reason to believe that the person is conducting criminal activity or is about to do that. Well, what do we have here? We have what I believe to be a teenager, from deductive reasoning here, sitting in a public park, ostensibly within operating hours of that park, and seated in the driver's seat of a parked motor vehicle. I say a teenager because when Deputy King inquired as to whether he was in his 20s, he said, well, getting close or something to that effect, like approaching my 20s or getting close to my 20s. So he doesn't talk like somebody who's on the other side of his 20s, so I'm assuming he's 18, 19 years old. So we clearly don't have any reason to suspect him of trespassing here, and as far as we know, we don't have a suspicious person call. The officers admit they just patrol the area and they get out and talk to people. So is the cop off base here? Is he getting ready to do the walk of shame? Sometimes when the internet believes a person is winning an exchange with a police officer, it's actually just an officer deciding it's not worth the trouble. I've seen countless walk of shame videos where the person was wrong and the cop just let it go. That's actually a good thing. We all win those exchanges because it proves that there is at least something in the lizard brains of some of these officers that suggest, bad juju. The lunk alarm sound from the local Planet Fitness goes off in their head and they grunt, oh, this one's not worth it. Must go get Monster Energy drink or whatever. Sorry. Sometimes I write stuff and I get tickled at myself and I can't finish. What happens if you should ID, but you don't? What happens if you're wrong and the officer decides, I'm going to take advantage of this one. I'm going to jump on this guy because he's supposed to identify and he doesn't. Well, failure to disclose identification is also covered under Utah law, 768301. And they say, an actor commits failure to disclose identity if, during the period of time that the actor is lawfully subjected to a stop as described in 77715, remember, that's not the driving code, that's the one we just covered. A peace officer demands that the actor disclose the actor's name or date of birth. The demand described in subsection 2A is reasonably related to the circumstances justifying the stop. So we have a scope there. We have to be tailored to the thing that you're stopped for. And C, the disclosure of the actor's name or date of birth by the actor does not present a reasonable danger of self-incrimination. So we've protected the person from self-incrimination. We ask just that they give the name or date of birth. And D, the actor fails to disclose the name or date of birth. A violation of this is a B misdemeanor. So again, ostensibly arrestable. That's kind of interesting, right? The stop and ID law says failure to disclose is a Class B misdemeanor, ostensibly an arrestable offense. And the driving statute says that failure to exhibit is an infraction. So notice that you have two separate things here. You have a criminalized failure to disclose, and it's in a separate statute. And then you have a failure to exhibit penalty that is within the same statute for the driver requirements under subsection 3. It's almost like the legislature knows that if they don't put it in the same section the officer's presently reading, that some cop somewhere might run out and arrest somebody improperly for it. So the legislature is intentionally guarded against that to the extent that they possibly can. And you can kind of tell by the fact that this officer, who does have some age on him and maybe just doesn't want to deal with it, but he doesn't force the issue because he realizes that he doesn't have reasonable suspicion that the person is committing a crime here. But again, remember the final statement. They're going to sit on the car and they're going to wait, and eventually they'll find a reason to pull him over, and eventually, even if they have to lie about whether his eyes are glassy, they're going to get their pound of flesh out of this kid. But that's not the point. Legally speaking, they really didn't have anything to go on here. And so what they did was ultimately the walk of shame. But we'll see in the grand scheme of things, Davino won the battle, but will he ultimately win the war? Who knows? In closing, I just want to kind of talk about what could have happened here. A lot of my law practice, specifically a part of it that I tend to keep to myself, is representing juveniles in delinquency matters and acting as a guardian ad litem for abused and neglected children. I do those cases on an appointed basis for whatever the state minimum fee is, because that's part of my practice that I like to keep, where I can represent indigent people. And specifically in my juvenile cases, I'm dealing with kids who have either never had hope or they've lost hope. And a lot of times they have no leadership at home. They have no reason to think that life is going to get better tomorrow. I literally sometimes have kids accused of truancy who live 15 miles from school, have no vehicle, have no parents. They're dually enrolled in college as high school students, making A's on college courses while simultaneously failing their high school courses because they have no support at home and no way to get to school. And I'm not a touchy-feely, like hug-a-thug type guy. I'm really not. I'm not a big feeling person. But kids are sort of my weak spot, and old people and people with disabilities. And when I think about those kids, I think, my God, what about this life has been shown to this kid to make them want to get up tomorrow? And it's heartbreaking. And I'm not saying that's what's going on with this kid. So Davino, if you ever happen to see this, I'm not saying you don't have a home life. And I'm not trying to cast aspersions on your family, because God knows you can't tell that by this video. And I'm not assuming that you don't have support. I just think about the kid who's sitting in a park somewhere thinking about walking into the woods and hanging himself from a tree because he doesn't have any reason to try again tomorrow. And he doesn't have any reason to think that it ever gets better. This kid's talking about how he's quit smoking and he hasn't smoked for a while because he's doing everything he can to better himself. And what good does that do him? What good has it offered him right now? He clearly still doesn't have that job because he's sitting in a park, killing time. The cops have shown him that he's going to be treated like a criminal no matter what he is or what he's chosen to do. So what if the next kid is a little bit less strong than Davino is? And then when I think about that kid, I think about the incredible and tragically wasted opportunity these officers had to actually show concern to the kid sitting alone in a park. Instead of treating him like a criminal, what if they were just friendly instead of demanding? What if they just came up to him and said, "Hey man, beautiful day. You okay? Are you good? We're just checking on you. We're just out doing our thing, just checking on you, buddy. We saw you here by yourself. Is there anything we can do for you? How would that have taken anything away from them or their ability to investigate that situation? In fact, it might have caused him to be disarmed and talk to them. And they might have figured out what was going on. Maybe they would have figured out nothing was going on. And maybe they would have restored some confidence in that kid in law enforcement. It doesn't take much reflection to figure out why people have negative thoughts about the police when you see stuff like this. Not everyone behind the badge is good, and not everyone not behind a badge is bad. We're all people, and we deserve to begin an interaction with the police with some modicum of offered respect before something is demanded of us, especially where those are supposed to be consensual. So if you're a cop watching this right now, the way you talk to someone tonight on your shift might actually be the reason they decide to try again tomorrow, or might actually be the reason that they decide, forget, what's the point? So please think about that. That's all for this one, guys. Thanks for sticking it out. Please remember to like and subscribe and leave a comment on the video. Please watch some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.